Welcome back to Arbitral Voices. Today I am pleased to be joined by Jose Garcia Cueto, also known as Coque, who is a partner in the Washington, D.C. office of Clifford Chance. Coque specializes in commercial and investment arbitration in Latin America and US. Coque, thank you very much for joining us today.
Thank you for having me, Shay.
To kick off the conversation, I would like to know, why did you choose to pursue your career in arbitration?
Well, I didn't choose it. It was not something that I had decided. It was more something that happened. Initially, I was a litigator. I started my career in Spain. And within the litigation group, I saw people didn't like infrastructure projects. When big infra litigations came in, people didn't enjoy them, and I loved them. I became obsessed with them. The problem I saw, Shay, after a couple of years working on those projects is we were getting just the crumbs. We weren't getting the whole bread. Big infra projects were typically either, if they were litigated, they would be litigated typically in England, considering I was in Europe, and if they were not litigated, they were arbitrated. So that got me curious, because arbitration was not a thing. I'm taking you back to 2007, 2008. There weren't many arbitration practitioners in Spain. Arbitration was not very common in Spain. It was sort of a niche. So in order to understand more about it and see if I was really interested in it and I could pursue a career on that, I came to the US. And I came to the US, honestly, just for 1 year. Like, my plan was to go back to my firm, continue working, try to develop a practice there. And almost 12 years after, here we're having this conversation. Why did I stay? Which is sort of what really answers your question. Because I saw that here I could have a platform to do what I really love, which was big infrastructure projects. And what I hadn't realized is how many Latin American clients and how many Latin American disputes are serviced from New York and DC and have a connection to the US. So after my master's, I had a contract for a year. I was like, okay, this is going to be fun. I'm going to spend 1 year. I'm going to do infra projects in Latam, and then I'll head back to Spain. And at least for now, I never made it my way back home.
And as a foreign lawyer in the US, did you encounter any obstacles?
That's a difficult question to answer. I would say, in short, yes. The question is, how would you understand obstacles? I think the difference between my original perception of a lawyer in Europe and lawyers here in the US is specialization. In Europe, when, let's say, you're in a litigation group, you do any kind of litigation. You do insolvency, you do restructuring, you do litigation, you do arbitration, and on any kind of sector. Whereas here, when I came in, they kept asking me, what do you specialize in? And I didn't know how to answer that question, because I would always say, well, infrastructure projects, because that's what I've been doing. But that didn't mean I was a specialist. And I think the lack of confidence to say this is exactly what I'm doing was one of the challenges. The second challenge was, there's no easy way to put this one, is I was seen sort of a not second class citizen, but different kind of lawyer. In the US, in big law, typically you see that you have all the JDs, and then you have a small quantity of people who are foreign trained, then came to the US, took a master's, and passed the bar. But it is less common that those lawyers are fully involved in US matters. So it took me some time to gain that trust from my US colleagues, for them to, let's say, allow me to play in their playground, allow me to deal with US related matters, allow me to help them with issues, technical issues that also involve a US component. That, I won't say it was an uphill battle, but it was something that it took time. But luckily I managed, and now we're running US arbitrations within our group, jointly with my US colleagues. But I think that was, trust is a difficult animal to deal with. and it takes time. So whoever endeavors this path, I tell them, please be patient. If you challenge yourself, if you're passionate about what you like, and if you keep trying, people will see that. And someone who puts 100% of their effort every day on what they do, very rarely not succeed in what they do.
And so today you do arbitrations in relations to infrastructure projects which are based on contracts. Right? And so my question is, what do you think is a good arbitration clause in an infrastructure contract or in contracts in general?
That is a very interesting question that I've asked myself many times. My practice is mainly focused in infrastructure disputes, and those infrastructure disputes, typically, I would say 75% of them, 70% stem from a contract. There's always relation to a contract. There are also treaty cases, but when they are contract related, almost all of them have arbitration provisions. And the question is, what is a good arbitration provision? And my answer to that would be twofold. The first one is a short arbitration provision is typically better than a very convoluted arbitration provision. And here, one of the main issues that I've seen is people do not spend enough time thinking about their arbitration agreement. And this is something that doesn't. I keep telling the corporate folks, I keep telling my clients, guys, your contract has X provisions. They are all as important. But you can see when clients negotiate, when corporate lawyers negotiate, typically the indemnity provision, the liability provision, the cap provision, scope, they are way more interested in discussing where the commas go there than on what the substance and the relevance of their arbitration provision is. And again, it makes sense because when you're trying to sign a contract, it's like a relationship. You're in that we're falling in love, where it's that beautiful moment in which the parties are trying to come together. And they're not thinking about down the road what will happen if they eventually divorce or split apart. So there is less focus on that. So what I would tell people, and now I will turn to specifically answer the question, is devote time thinking. What is a good arbitration provision for that contract? For instance, think about basic stuff like, do you want an administrative arbitration or not? And if you do, which I encourage using an administrative, because administrative bodies help. Having exit, having ICC, having the ICDR assist you with the arbitration is typically very useful. It makes arbitrations faster. Think about the language of the arbitration. Many arbitration provisions have no language. But when you think about the language, you have to think about the applicable law. You have to think about the underlying documents. I've seen dozens of arbitration provisions in which the parties agreed to a language for the arbitration, but all the underlying documents, all of them are in a different language. You know the cost that implies to translate hundreds of documents? Infrastructure projects are projects that take years. If you don't think about those things initially, down the road, if one party doesn't want to consent to to bilingual arbitrations, well, that is a problem. Think about the language also in context of who your pool of arbitrators and experts are going to be. Maybe nuclear plants, for instance, have different type of potential arbitrators and experts than, let's say, a gas pipeline, because it's more common, or a road, which is very common. I would also encourage parties to agree to a seat of the arbitration. Just think about enforcing the arbitration. the discussions you can have with no juridical seat agreed upon the parties, and the objections on courts that you may file are so different. You are not doing your client a favor by not thinking of these things. The last thing I would encourage people, and again, some of my colleagues will shoot me for this, but don't get creative. Model clauses are beautiful clauses. They are tested. You can use that and add some stuff. I don't know, language, distribution of costs, seat, governing law to the arbitration agreement, but less is more, typically in my experience, particularly for arbitration agreements. There is one other thing that is not specifically related to arbitration agreement, but to dispute resolution provision. In big infrastructure projects, typically the people at a project level fight a lot, clash a lot. But if you allow your dispute resolution clause to have an intermediary step, a multi-tier agreement by which you bring to the table different people, senior management, for instance, before filing for arbitration, that typically reduces the amount of disputes. Some people will encourage you, and I've seen, and I've done quite a lot of work with dispute boards. Dispute boards are also efficient for that. However, my view on dispute boards is they typically only work to the extent it's a linear or continuous permanent dispute board. When you have a dispute board, sort of like an arbitration, they only come in when the dispute happens. Then basically what you're giving your client is two different arbitrations.
Now, some of these infrastructure contracts are signed with public entities.
Yes.
Are there any specificities that one should keep in mind when entering into a contract with a public entity?
Yes, both. If you're the attorney, so why are many of these contracts entered with state-owned entities? Because at the end of the day, many times the state-owned entity is the sponsor to the project. It's the government that wants to pursue that project or that infrastructure and hires, for instance, an EPC contractor. And in that EPC contract, you have this discussion of what is good for the state, what is good for the sponsor. For the contractor. My view on what is important, two things are important. The first one is we need to remember arbitration agreements are contracts within contracts. So the first thing is there needs to be specific consent from the state, whatever the applicable law is to that, as to the arbitration agreement. And that has to be dealt separately. You need to hire whatever the governing law is. You need to be very sure of what those steps for necessary approvals are. We've seen too many times both defending states and, defending the EPC contractor, in which, the sovereign party takes the position that it did not rightly consent to the arbitration under its applicable law. And yes, you have the Millicom cases. You have Paulson wrote an article in the 80s, a very good article in this respect. But that doesn't mean there's a risk there. So in order to avoid those headaches, the first thing you have to do is be sure that all necessary approvals are there. The second thing that I've seen that is a good contractual remedy for the EPC contractor to take coverage is get a rep within the contract. Get the other side to represent, and it's a quite standard rep, just apply it to the arbitration agreement, that all necessary consents, that all necessary approvals by the state and by the state-owned company were obtained before agreeing, in order to agree to the arbitration agreement. That typically will, I won't say prevent the objection down the road in the arbitration, but I think arbitrators will be more reluctant to grant an objection of this nature when there has been a specific representation in this sense. Because at the end of the day, let's say we're sitting in DC, that would be a promise. And breaching a rep of that nature typically is a material breach. So parties typically will think twice before making an objection of that nature. So those are the two things I would say. First, consider what your all the necessary steps under the underlying law to the arbitration agreement are. Second, get a very nice rep to the extent that you can get it, saying all necessary approvals were there, including for the arbitration agreement.
So now, if we speak specifically about contracts entered into with states, I'm thinking from the point of view of enforcing an award and states raising their questions of immunity from enforcement. Do you think EPC contractors or any other contractors can deal with that questions in their contract to avoid any issues that may arise in enforcement?
The short answer is yes. The real answer is it's not that easy. Can they deal with it at a contractual level? Absolutely. You can agree so many things with respect to sovereign immunity. You can agree to so many things as to what does the state waive or does not waive. Which, as we've seen it, we've helped clients. Which assets you can go against, which assets you can't touch, which assets are within the jurisdiction of the states, which assets are property of the state outside of that jurisdiction that you could enforce against. We're actually seeing it not at contractual level, but at a practical level with Spain. That the main discussion is going to be typically what is a commercial asset of the state. But that's sort of the textbook answer. In practice, it's not that easy, and I'll tell you why from my experience helping contractors negotiate. Because the state is not willing to have that discussion at a contractual EPC level. And the EPC contractor typically doesn't have the leverage to have that discussion at that point. EPC contracts, construction contracts, typically come from construction bids. So you have multiple players trying to gain a contract from the state. And within the realms of their offers, typically those offers have limits, or either imposed by the state or imposed by the contractor. Trying to negotiate with a state, unless you have, again, leverage on the negotiation, it's something so specific, you are the only EPC contractor that has done that, which is extremely rare. The state will not entertain that discussion, and if you push, typically what will happen is that will become a deal breaker, because it will become offensive for the state to have to negotiate what assets you are going to go against, or what in which jurisdictions you're going to go to chase them for money if they don't pay. So again, can the EPC contractor do it at a contractual level? Absolutely. Have we seen it? Yes, we've seen it. Does it work? Typically it doesn't, and you can alienate the sovereign. So if you are an EPC contractor, you are dealing with these kind of issues, you have a real concern at a contractual level that is going to be a problem. Well, I have two comments on that. The first one is maybe you're not contracting with the right entity and you're taking too much risk. The second is if at a commercial, if you have the appetite for that risk, be careful and be very constructive as to how you're going to propose first the conversation and second the framework of the legal discussion within the documents, because you may be alienating your counterparty, and that's the last thing you want to do when you're trying to, let's say, enter into a relationship with someone.
And from that, I'm wondering, at the beginning of the arbitration, how much thought is given to the enforcement of an award? How much thought is given to asset tracking to make sure that if the other party does not pay, whether it's a state or another commercial entity, you will still have an award which you will be paid in some way?
Less than it should. Typically, clients don't want to spend money in asset tracing at the beginning of the dispute. However, my view on that is having a wonderful piece of paper that says you win with an amount of dollars or pounds or euros, but you can't collect. It's just a wonderful piece of paper, just a very expensive one. So, at least my recommendation to clients is when there is a justifiable doubt as to whether you're going to be able or not to collect against your counterparty, at the outset, as part of your due diligence of the case, you should do asset tracing. First, because you're going to have to do it at a certain point in case you win. Second, because it will allow you to decide how to move forward. Let's say at the outset you conclude there's no assets. Then maybe commercially you'd rather go for a settlement or just drop the case than spend a lot of money from your shareholders in order not to have your money back. So I encourage my clients always to think about enforcement at the outset of the case. When they are analyzing the case, part of that analysis should include enforcement. And again, it is less common than you would expect, and the reaction of clients, both stateside and private clients, is, why would we do this now? Well, because spending some money now will prevent you from throwing good money into bad.
To finish, I would like to get us to the issue of contracts in ISDS, and specifically with the increased amount of termination of BITs and talks, specifically at the EU level. I'm wondering whether you think that we are going back the road towards more and more contractual based ISDS cases.
Don't have a crystal ball, of course. I can tell you the trends I'm seeing and what I think. The trend, unfortunately, that I'm seeing is more states adopting more regulatory measures that impact investors, and then more states, unfortunately, thinking it's the system that's wrong, it's not my measures. That has, on some states, not all of them, some states, has built up a narrative in the last 15 years that investor state is a bad thing, when it's not. Like, it is proven. There are already papers. Before they said, oh, there's no extrinsic data. There are papers already that show that having BITs, that having treaty protection is good, attracts investment, and what's more important, cost of capital for projects lowers. Banks now, investment banks, lenders now, for project finances, consider in their pricing and in their risk profile whether the state has or does not have investment protection, and whether the state complies or does not comply with those awards against the state. Unfortunately, again, I think what I'm seeing is this narrative is building up, and so the push that we saw in the 90s, in the early 2000s, to sign more and more bilateral, multilateral investment treaties with investment protection or with a broad investment protection is narrowing. If you see CTTP, other treaties that are now being NAFTA 2.0, the scope of the investment protection chapter is narrow. And my view is this is a result of this misperception that, or this narrative that investment protection is not useful for states and does not help commerce, does not help trade, does not help investment. So if that is the case, well, two things are going to happen, in my view. The first one is we're going to see more PRIs. We're going to see more insurance policies for political risk. And those insurance, but the problem with those insurance policies is they're very expensive. And because they are very expensive, then parties are going to say, well, what what is my fallback? What can I do if I don't want to pay this insurance? The fallback is contractual contracts with investment protection provisions or with ISDS provisions that will allow the parties to recourse to arbitration, to recourse to ISDS in case there is a dispute. And this is not something new, just to be very clear. This has already been happening, particularly if you see, for instance, the cases of Peru. Its model contracts of pro-inversión have an exit clause. Honduras, same. Its PPAs have mandatory arbitration and have exit provisions for contracts. So for big infra projects, it is a very good way of lowering the risk profile of the investment. And I think this is going to continue with the ACT being announced, for instance. That is a good way, sort of alternative to try to tackle ACME and Comstroy. Will it work? Again, we'll see what states do, but I think that there are ways to lower the risk profile, and that means lowering the cost of capital of investments. And I think they are going to be used more and more. And one of those, I agree with, well, it's not that I agree with, I think is going to be using contractual ISDS.
And just to conclude, from a practical point of view, are there differences between conducting an arbitration on the base of a treaty and on the base of a contract?
I would say classic lawyer answer, it depends. The real answer is yes, it's quite different. On the contractual ground, you're basically arguing the plain language of the contract, or whatever. It depends on the governing law. If it's more a U.S. or English, you're looking more at the four corners and less at extrinsic evidence. If you're looking at more at civil law contract, then you're looking more at extrinsic evidence, because civil laws are more prone for interpretation of the contracts, whereas treaty-wise, well, you have the treaty and you have the provisions, and you have to look at, typically, you have export, you have VT, you have the boilerplate of protections, and one of them or multiple of them will be invoked, and then the question will become what the wording in the treaty means, whether that wording is different from other treaties, and how that is covered or not by the facts. I think the realm of what you're going to end up doing is the same, which is apply facts to a law and law to a conclusion, but many of the issues are like how you approach damages is different typically. How you approach jurisdiction is typically different. Merits, it's not that different than facts. Again, you use the facts differently, but not that much. So again, not maybe the most clean answer, but I would say again, every litigation is different, but those are two very different worlds.
And on that note, we will end for today. Thank you very much, Koki, for joining me, and thank you as well for joining this episode of Arbitral Voices, and I'll see you next time.
Thank you, Shay. It was a pleasure being here.